What happens when one guilty plea changes far more than a criminal record? In today's emotional courtroom hearing, a woman learns that a family violence conviction could affect her right to own a firearm, future child custody, and many other parts of her life, consequences she says she never fully understood. As Judge Stephanie Boyd carefully explains the law, the courtroom fills with confusion, emotion, and difficult choices. Stay until the end to witness how this life-changing case unfolds and what decision ultimately changes everything.
That you have an active warrant for?
It had been for a failure to ID.
All right, State, can you see if there are any pending charges other than this case?
Yeah, there's a failure to ID. Oh, sorry.
Solid.
I did not understand that one. Yes, ma'am.
And with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent. Did you understand that?
This is the first time I heard of that.
All right, so I'll let you all step back. So
what does that mean?
I'll let you speak to your attorney about that.
I'm not allowed to have children?
0042, State of Texas versus Brittany Merrill Brown. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense. And are you Ms. Brown?
Yes.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Ms. Brown, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it and did you sign it? Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Waive it, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we move to waive the advancement and proceed as a Class A listed in your assault.
Any objection?
No objection, Your Honor.
Ms. Brown, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on the lesser included offense of assault, bodily injury, married, cohabitation as a Class A misdemeanor? The range of punishment is up to 1 year in jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargaining agreement with the state, the court doesn't have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
I did not understand that one.
All right, you don't understand you have a right to jury trial?
I heard it, but I didn't hear.
All right, so do you need to speak to your attorney?
No, I just didn't. Please repeat the question.
Do you understand you have a right to jury trial?
Yes, I don't hear the.
All right. Do you understand that you have a right to have your attorney cross-examine or question any witnesses the state would call?
Yes, ma'am.
Did you understand you have a right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you're giving up your right to a jury trial?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you're giving up your right to have your attorney question or cross-examine witnesses?
Yes, ma'am.
Did you understand by entering this plea, you're giving up your right to remain silent?
Yes.
And did you intend to do that and enter into a plea bargain agreement today?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Brown, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, punishment is to be assessed at 1 year in the Bexar County Jail. State recommends community supervision. There's an affirmative finding of family violence. I'm going to need you all to be quiet in the box, please. There's an affirmative finding of family violence. There's to be no harmful or injurious contact with Tegui, Tegui. Bizou, Biezou. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
That's forever?
You're not allowed to own or possess any weapons or ammunition. Do you understand that?
I mean, yeah, but I can never, for protection, have.
You need to speak to your attorney about that. But with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition.
Okay,
Do you understand?
yes, ma'am.
And with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent. Did you understand that?
This is the first time I heard of that.
All right, so I'll let you all step back. So
So I know, what does that mean?
I'll let you speak to your attorney about
I'm
that.
not allowed to have children?
Oh, you can have children, but if there's some sort of custody issues that arise, technically and legally, the court is not allowed to have you as primary custodial parent. Now, if in the best interest of the children, they determine that you would be the best placement, then they can do that. But if there were any type of custody issues and there's a person who appears to be a good parent and they don't have an affirmative finding of family violence, then they're supposed to be designated as primary custodial parent. I'll let you speak to your attorney about it. So I'll have you all step back and you can talk to your attorney. Back on the record, in 2023 CR 0042, Brittany Brown. We were on the plea. So did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the entirety of the plea bargain agreement? I don't understand what's going on here.
But I'm not gonna be able to have my kids?
I'm not your attorney. So the only thing my job is to make you understand what the plea bargain agreement is. I've explained to you with regards to the meaning of an affirmative finding of family violence, and I always give people those instructions so they will know. Because many times when people enter pleas on the criminal sides, they have an impact civilly and in other ways. So with all of these family violence cases, when there's an affirmative finding of family violence, there are certain collateral consequences. One of those is you can't have a weapon. You can't possess ammunition. That's how it is in Texas. I can't tell you how it is in other states. But you can't have weapons, you can't have ammunition, and you can't be designated as primary custodial parent. So legally, you can't be designated as primary custodial parent. Those are the consequences of entering a plea, and those are the consequences of having an affirmative finding of family violence. Now, if you would like to, counsel, we can bring this back for tomorrow.
So, okay, fine.
All right, that's what I'm doing. I'm gonna have you all take a seat just to talk about
I do understand it, but it's just it's a horrible thing for that, like, to have, it's horrible. So I understand it, but
I mean, all the cases here are horrible. They're felony cases.
I thought it was getting reduced.
It's still getting reduced, but it's still, all these cases have consequences. Whether it's being reduced to a misdemeanor or not, there are consequences that flow from felony cases and consequences that flow from criminal charges. So what I'm going to do is I'm going to have you sit with your attorney, because I want you to, if you're planning on entering a plea in this case, I want you to enter it with a clear conscience and a clear understanding. So it appears to me, and I may be wrong, I'm making assumptions here, that you didn't know the consequences civilly of entering a plea in this case. And the fact that you're talking to me about, am I ever going to be able to possess weapons? Am I ever going to have my children? That's something that you need to discuss with your attorney, and it needs to be in a setting. I don't want to say without passion or objectively, because I know these are all personal matters, but it needs to be something that's thought about with clear head and something to think about. All right, so I'm gonna have you all step back. And if your attorney feels like it's best that this be taken up tomorrow, we'll take it up tomorrow. I'm here all week. All right, so just step back and discuss it with your
I
attorney.
understand it. There's nothing I can do.
All right, just step back and talk to your attorney. Go back on the record in 2023 CR 0042, State of Texas versus Brittany Brown. So, Ms. Brown, I've gone over the plea bargaining agreement with you. Did you understand that to be the plea?
Yes, ma'am.
And do you understand the consequences of entering a plea with an affirmative finding of family violence?
Yes.
And knowing that, do you wish to proceed?
Yes.
All right, did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, the any such motions?
No, Your Honor.
And counsel, did you understand that to be the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be 100 hours of community service restitution, the BIPP, a TAP evaluation, and follow all recommendations from the TAP evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence?
Yes, sir. I just have data for state exhibit number 1 and staff.
No objections, Your Honor.
Ms. Brown, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
He has had two problems, I guess, communicating and understanding what's happening, but after explaining several times for the situation, she understands everything, and we're asking that the court accept the recommendation from the state. Please don't defer.
All right, what was your warrant for? In the police report, it says that when the complainant called the police showed that you had a warrant. So what did you have an active warrant for?
It had it in for a failure ID.
All right, state, can you see if there are any pending charges other than this case?
Yeah, there's a failure ID. Oh, sorry.
Your Honor, there's a failure to ID, and that one is, according to the state, would be TIC.
It's not listed in the plea.
Judge, there is, but we can, I can enter a dismissal. I think you just give me a couple months to fill out a dismissal.
All right, thank you. All right, are you employed?
At the moment, no, I'm not.
How do you support yourself?
I'm living with family right now.
What family is this?
My mom.
All right, and Child Protective Services were called. Is Child Protective Services involved?
Yes.
All right, this is what the court is going to do. 2 years deferred adjudication. There's an affirmative finding of family violence. Well, let me strike that. The state is requesting that actually you have a conviction. What the court can do is you can have a conviction. That's what you bargained for, or either I can give her deferred adjudication.
We've, deferred adjudication in the actual.
All right, if the court were to give you deferred adjudication, if anything were to happen and your probation were revoked, you could end up with potentially 1 year in the Bexar County Jail. What the state has offered you, if you were to not do well, you could still end up with 1 year in the Bexar County Jail. So which would you prefer? Would you prefer conviction or deferred adjudication?
Conviction.
All right, court will sentence you to 1 year in the Bexar County Jail.
No, miss.
You said a conviction.
Oh, I thought, okay, I'm sorry. Oh my God, no.
So are you
I thought
asking?
you meant like on the record.
Are you asking for deferred?
Yes, ma'am.
All right, with a deferred adjudication, the court could sentence you to up to 1 year in the Bexar County Jail if you are unsuccessful. Do you understand?
Yes.
And up to a $4,000 fine. Do you understand?
Yes, ma'am.
And are you requesting that the court give you deferred adjudication?
Yes.
All right. The court will sentence you to 2 years deferred adjudication. There's an affirmative finding of family violence. There's to be no contact with Tagai Buzu. If there are some kind of child custody arrangements that need to be made, you'll need to make those through a third party. If you wish to have contact with him, he'll have to come in to court, and I'd have to hear some evidence with regards to that. There's to be 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. I'm going to request parenting classes. CPS should give you parenting classes. CPS compliance. Probation, if CPS is giving her parenting classes, then she can then the court will accept parenting classes from CPS for her. There's to be the BIPP course, TAP evaluation, and whatever the TAP comes back with, we'll start with supportive outpatient treatment. And again, if CPS is giving her alcohol treatment or drug treatment, then CPS can do that, and that'll be acceptable. Regular UAs, I'm going to want field visits at least one time per month until further notice. Regular reporting, in person or by Zoom. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. Probation, is there anything else you need?
No, Your Honor.
Is there anything else you need from the court in order to be successful? Anything else you need, Ms. Brown? I can't understand that.
You said, what did you say about minors?
You're not to have any employment.
Oh, like a daycare. Okay.
Yes. And you're to follow all CPS compliance rules. Did you review this document with your attorney entitled Trial Court Certification of Defendant's Rights to Appeal? And did you understand it, and did you sign it? Did you review that document with your attorney?
I'm sorry.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Yeah. All right, good luck to you. 6, State of Texas versus David Kianis. The second, could I have parties announced for the record for the state?
Jason Garrett, for the state, Your Honor. Brian Kimbrough, for the
Are you Mr. Kianis?
Yes, Your Honor.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you have a chance to review that with your attorney? Did you understand it?
I did, Your Honor.
Are you the same David Kianis II who was placed on deferred adjudication in 2021 CR 9806 for the offense of aggravated assault with a deadly weapon on November 16, 2022 for a period of 8 years? Is that you?
That is me, Your Honor.
All right, state.
Yes, Your Honor. Violated condition number 2 on or about the 28th day of April 2023 in Bexar County, Texas. The defendant, David Kianis II, did then there illegally use a controlled substance, namely methamphetamine, in violation condition number 2.
How do you plead to that? True or not true?
It's true, Your Honor.
waive the remaining violated conditions, Your Honor.
Any objections? Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
I do, Your Honor.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor. And the recommendation from the probation is also the same, to deny the motion to do the adjudication of guilt and continue the individual on his deferred, and to have him enter the DDRF, followed by outpatient and 180 days in sober home.
Is that what you're asking the court to do, defense?
It is, Your Honor.
All right, Mr. Candace, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, Your Honor.
All right, you can lower your hand, state your name for the record.
David Eunice II.
All right, Mr. Kianis, why are you not being successful on this probation? And here you are, back on the same day that I gave you probation, the 16th. So why are you not doing what you're supposed to do?
I don't have any valid excuses. I've been doing the best that I can out there, and I'm in a lot of the wrong places. I didn't pay my phone bill. I didn't have the available open opportunity for probation to contact me. And that's my fault. That's why I wasn't able to follow some of the conditions. But it's not something that I wish to continue doing. I just want the opportunity to be able to make this right. And
Well, this is a case where the state wanted you to go to prison, and your previous attorney brought me medical issues concerning you, mental health issues concerning you. So I'm the one who gave you deferred. And instead, what you're doing is using drugs. And then I even tried to address the mental health issue, and I'm not taking it as truth, but we're trying to get to the bottom of what's going on with him. I even had you go to the mental health initiative, and you're not doing that. You're doing nothing. You're just coming to me with your hat in your hand and saying, please don't revoke me. So I don't understand how things would be differently if I were to follow the agreement and not revoke you. So what are you doing?
I'm just trying to do the best that I can out there. And
But what does that mean?
I've had a unstable home environment, and I haven't been home as often because it hasn't been a very positive place to be.
Okay, well, how old are you?
36 years old.
All right, who are you living with?
My father.
All right, so obviously, maybe your father doesn't want you there, or you don't want to be there because you don't think it's the best environment. Am I right in that?
You're right in the fact that I don't want to be there. It's just there's drug usage in the house, and I don't want to get in trouble for that.
Okay, so why don't you have a place of your own?
I'm on disability. They take child support out. I'm not making enough per month to support myself.
Okay. Probation? I don't know what we can do with Mr. Kianis. Where is he going to be living? I mean, I know everybody said sober home, but
So I know that was a recommendation, and I had spoken with defense counsel about it. I mean, he would have to, for the sober living environment, I mean, that is something that is also requires payment, and it's like a rent. You have to rent a room. So, I mean, there's the financial obligation for that as well.
so does anybody know how much it costs?
I think it varies per house. So he has to, I had explained that they have to kind of apply to enter the sober living home. And then the sober living home has to be willing to accept him as a resident.
Well, will Lifetime accept him?
I believe that they will accept him. I know that we had talked about some medical issues that he has. And so I had explained, even in an inpatient setting, I don't know what his medical limitations are, but we can certainly try Lifetime Recovery. And then maybe while he's transitioning out of Lifetime, maybe give him a referral to the reentry center. or maybe even recommend him to felony drug court.
All right.
That's another option that would have a lot of more frequent contact with him and from his management services.
All right. So I'll deny the motion, alternating conditions, and it's to be lifetime recovery, followed by a referral to felony drug court with their dual diagnosis program. Is there anything else?
Nothing to state, Your Honor.
No, Your Honor. Is there a lifetime recovery? Does that involve a process? And
Yes, and they will actually transport him from the Bear County Jail.
that's fine.
All right. Is there anything else you need from the court to be successful?
No, Your Honor.
All right, we can go off the record. From here on out, you need to get in touch with your probation officer. You just can't be out here on probation and not really on probation because you're not doing anything. Otherwise, you could potentially be going to prison for 20 years. You understand?
I do, Your Honor.
All right, good luck to you.
This courtroom case is a powerful reminder that every plea agreement carries consequences that can extend far beyond the courtroom. Judge Stephanie Boyd ensured the defendant fully understood the legal impact before making a final decision, highlighting the importance of informed choices and due process. If you found this real courtroom case informative, don't forget to like, subscribe, and turn on notifications for more authentic courtroom moments, legal stories, and justice system insights. Thanks for watching, and we'll see you in the next video.